So, in the political theater of American governance, the curtain now rises on a constitutional crisis performed in broad daylight. President Trump's deployment of 300 California National Guard troops to Portland, after being denied authority over Oregon's own Guard, is not just political audacity, it's a stress test of the republic itself. Days later, the U.S. Supreme Court, in a late-night order cloaked in the language of emergency discretion, sided once again with the administration, this time allowing it to cancel temporary protected status, TPS, for approximately 600,000 Venezuelans. Together, these actions mark the convergence of executive overreach and judicial surrender, forming a duet of power unchecked and principle abandoned. Governor Gavin Newsom's vow to sue is no act of defiance, it's an act of triumph. When the president can commandeer one state's military to police another's citizens, federalism begins to buckle. The Posse Comitatus Act, written to prevent such misuse of troops for domestic law enforcement, has become an inconvenient footnote. The president's rationale, dangerous cities and law and order, is less about security than spectacle, a show of dominance cloaked in legality. Each soldier sent, each protester surveilled, becomes part of a stage production where authority is mistaken for virtue. Meanwhile, the Supreme Court, once the nation's constitutional conscience, now plays the part of an enabler. In its emergency rulings, those unsigned, unexplained midnight decrees, the court has adopted the posture of quiet complicity. By lifting injunctions that once protected Venezuelan families, it has sanctioned chaos as policy. Families who fled tyranny now face deportation not for crime, but for convenience. Some keep protection until 2026, others face expulsion within weeks, all because judicial restraint has been replaced by executive accommodation. Across the Pacific, the Hawaii Supreme Court and other state tribunals are beginning to sound the alarm. They warn that the U.S. Constitution's guardrails are being dismantled not by force, but by precedent, that the slow corrosion of checks and balances is itself the new rebellion. Their rulings invoke a simple truth. Sovereignty resides not in the office of one man, but in the enduring consent of the governed. Yet in Washington, that consent is being rewritten into submission. Federal courts defer, the GOP Congress hesitates, and the people watch as state autonomy and humanitarian law are quietly bartered away. Judge Karen Immerg's Oregon ruling made clear there was no justification for federalized military force against peaceful protest. But the administration pressed on, using emergency authority as a weaponized script. Now, with the Supreme Court's blessing on both the military and immigration fronts, the presidency expands not by law, but by precedent unchallenged. This is no longer the slow drift of democracy, it's deliberate choreography by the script of Project 2025. From deportation orders to troop deployments, the instruments of governance have become props in a one-man play of power. The founders feared kings. They did not imagine a republic so enthralled by its own reflection that it would applaud as its institutions now the moral, civic, or institutional tissue of a nation begins to rot from within.